change, but I can't. I just want both the victim's family to know that I sincerely apologize. I know nothing I say can bring back the love. Can't fix the crime, and I apologize for that. I just want you to know that I was a kid when it happened. I was a kid. Yes, I was 18, but I was still a kid. I never wanted anything like this to happen to nobody. I'm not a bad person. I just made a bad decision. Yes, you all may hate me, and I understand this. I do. Nothing I said could change anything that happened. If it could, we wouldn't be sitting here right now. I was going through families that day. Both victims and my own. No, nobody deserves to die. Nobody deserves to lose anyone. But I want everybody to know that I sincerely apologize. That night, from that night forward, it took a lot out of me. I lost sleep. I didn't eat. Every night, I go to sleep in jail, thinking about the family that I ruined that night. Thinking about the days, if I knew it would happen, it wouldn't happen. But I did, and it did. And I sincerely apologize. There's nothing I can say or do to change it up. And I wish it could. But it can't. And I'm sorry for that.
Thank you. Anybody else come?
No one else, I think so.
All right. The court has formulated its decision based upon the overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. The court has considered the relevant sentencing guidelines provided in Revised Code 292911, 292912, 292913, as well as 292919. I can't agree with anybody more than Bailey. What you said is today is not the end. It's not closure. You're 100% correct. I hope, though, after this, that the families, both sides, while it's not closure, can start the process of healing. And I don't have the words. I've been up here for a long time now, and every time I think that I can't see evil on evil, and this is what we have here. Just families absolutely devastated. Your family devastated. Your life devastated. Over a couple dollars. And it might not have been planned. Over a few dollars. Look at the destruction you've caused. I'm sorry to the families. I wish this road gave me some sort of magic to make things go away. Or that my words somehow will make everything better, and they won't. Or this sentence will make things better, and I'm sure it won't. So I'm very sorry for all your losses. And I'm sorry to the McDaniel's family, too. I'm sorry for all of you. It is just an absolute tragedy that should have been prevented and could have been prevented. Over a couple of dollars. I will sentence you according to the plea agreement by the parties. First and foremost, though, based on your plea, you are on notice of your duties to enroll as a violent offender if you are released pursuant to 2903.41. I'll have your counsel fill out that paperwork with you at the appropriate time. As to count 1, aggravated murder, that'll be a life imprisonment with eligibility for parole after 25 years. As to count 2, aggravated murder, life in prison with parole eligibility after 25 years. As to count 9, aggravated robbery, felony of the first degree, that'll be 11 years at the Lorraine Correctional Institution. Sir, because you qualify for what is known as the Reagan-Stokes Law, which I'll note your lawyer's objection to, you are going to receive 2 sentences. You will receive what's called a definite sentence of 11 years, and you're subject to an indefinite sentence of 16 and a half years as it relates to count 9. Sir, there is a rebuttable presumption that the defendant shall be released from the service of the sentence at the expiration of the minimum term or presumptive early release date, whichever is earlier. That the DRC may rebut presumption if at hearing held under 2967.271, DRC makes specified determinations regarding the offender's conduct while confined, the offender's threat to society, the offender's restrictive housing, if any, while confined, and the offender's security classification. That if, as described in Division 2, DRC at the hearing makes a specified determination and rebuts the presumption, they may maintain the offender's incarceration after the expiration of the minimum term or after the presumptive earned early release date for the length of time DRC determines to be reasonable, subject to the limitations specified in Section 2967.271. That the Department may make the specified determinations and maintain the offender's incarceration under the provisions described in Division B2C2 and Division 3 of this section more than one time, subject to the limitation specified in Section 2967.271. That if the offender has not been released prior to the expiration of the offender's maximum prison term imposed as part of the sentence, the offender must be released upon the expiration of that term. As to count 10, aggravated robbery, felony of the first degree, that will be an 11-year sentence at the Lorraine Correctional Institution. Pursuant to the plea agreement, count 9 and 10 shall run consecutive to one another. The court finds that a consecutive sentence is appropriate pursuant to Revised Code 2929-19B2B and 2929-14C4. The court further finds that it is necessary to punish the offender, protect the public from future crime, and is not disproportionate to the seriousness of the conduct and the danger posed by the defendant. That one or more offenses were committed while the offender was awaiting trial on community control sanctions or post-release control, or that 2 or more offenses are part of 1 or more courses of conduct, and that the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct. Pursuant to the agreement, counts 1 and 2 shall run consecutive to each other, and again, citing 2929-19B2B and 2929.14C4, the court finds that it is necessary to punish the offender, protect the public from future crime, and it is not disproportionate to the seriousness of the conduct and danger posed by the defendant, as 2 or more offenses are part of 1 or more courses of conduct, and that the harm here certainly is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct, and sir, it would simply demean the seriousness of these actions. Therefore, again, it will be consecutive sentences to count 1 and count 2. Counts 9 and 10 shall run consecutive to each other, but concurrent to count 1, the aggravated murder. As it relates to count 9 and 10, if ever applicable, you will be subject to what is called post-release control, and that would be a mandatory minimum of 2 years up to a maximum of 5 years of post-release control. That means, sir, that the adult parole authority, and not this court, would supervise you. They again would supervise you for a period of 2 years up to a maximum of 5 years. The adult parole system would give you terms and conditions you must follow. Should you fail to meet the terms and conditions of the adult parole authority, then they can modify and or extend your supervision and make it more restrictive. They can incarcerate you for up to 1/2 the original sentence imposed by this court. If If you fail to appear for them, they can charge you with a new offense called escape, another felony where you face additional prison time. And if you commit new crimes while on post-release control, you can face the maximum penalty under the law if the new crime is committed. Your sentence then, sir, will be life imprisonment with first eligibility of parole after serving 50 full years. You will be given credit for jail time in the amount of 948 days and any days awaiting transport. I will waive any remaining fines, fees, or costs. You certainly are now indigent, and you will receive any jail time credit awaiting transport. Is there anything else that we need to do on the record on behalf of the state?
On behalf of the state, Your Honor, thank you.
Anything else we need to do?
Nothing on behalf of the defense, thank you, Your Honor.
All right, again, thank you very much, folks. I'm very sorry for all of your losses. We're adjourned.
Hold on,